Hi, everybody, and welcome back to Psychology and Law. Today we're going to be talking about interrogations and confessions. And this is definitely going to be one of those topics that people struggle with the most, but hopefully at the end of the lecture you will understand why this is so important. And when I say struggle with it the most, this topic, at least initially, people say, I don't think this is real. But then as time goes on, hopefully we're able to see that interrogations and the way they're currently run, as well as confessions, are actually a huge problem in our legal system. A story about Marty Tankleff. Marty was a 17-year-old boy who lived at home, single child or only child, living at home with his parents. His parents were a little bit older, and his parents were some of his best friends. They traveled together, they hung out together on the weekends. They were a very, very close family and kind of your stereotypical all-American family. Well, one day Marty woke up, went through his morning routine, went to the bathroom, took a shower, went downstairs to see what his mom was making for breakfast, and found both of his parents had been stabbed to death in the downstairs of the house. Obviously, he was very concerned, so he picked up the phone and called the police. The police arrive, and in the course of their investigation, figure out that there's no actual sign of forced entry into the home. And so what ends up happening is Marty becomes the primary suspect. So they take Marty down to the police station. This was during a time, I believe it was in the late 80s or early 90s, when juveniles did not have the rights they do now, where they have to be interrogated with a lawyer or parent present. While getting interrogated, the police told Marty a series of 3 lies. The interrogation, by the way, took 18 hours. The 3 lies were, number 1, it was a very bloody crime scene. Marty initially said, I couldn't have done it, I'm not covered in blood. The police said, well, we did a humidity test in your bathroom and figured out that you showered in the morning. So you clearly murdered them and then showered off. And Marty said, well, no, I just showered in the morning. That doesn't make any sense, right? But I could see where the police would think that. They said, line number 2, Marty, we found some of your mom's hair, or some of your hair under your mom's fingernails. Marty's able to kind of explain that away too and say, well, yeah, no kidding, I live in the house. She died in the office on a carpeted floor. My hair was probably on the floor because I live in the house. The hair naturally falls out. That seems reasonable that maybe she would have some of my hair under her fingernails if she was clutching the carpet when she was getting stabbed. Then they told him line number 3. And line number 3 was basically that Marty's dad hadn't actually died. That on the way to the hospital, the paramedics felt a pulse, pumped him full of adrenaline, and he woke up and said, Marty did this. You need to go get Marty. Marty didn't really have a good explanation or way to rationalize that. And he believed that the police were telling him the truth. And so Marty struggled with that and said, golly, my dad's one of my best friends. If he says I did this, I must have actually done it. And so, again, after a 17 or 18-hour interrogation, Marty curled up in the fetal position underneath the interrogation table, who less than 24 hours prior discovered that he was now an orphan, that both his parents had been murdered, had a confession written for him, and they told him, if you just sign this, you can go home. So he scribbled his name on a confession, and I believe it was 13 to 15 years he spent in prison for a crime that he did not commit. Now, that's a kind of, sad story, and we're going to talk about some of the psychological aspects that took place over the course of this interrogation. We have a comic here that shows, the way, interrogations typically look, right? Obviously, there's not usually a police officer behind the glass making funny faces, but typically it's police talking to a suspect. So there are a lot of different roles of police interrogations in generating confessions, right? And one of the first things we need to talk about is the fact that there are only 2 real goals to interrogations. The only reason the police will ever pull you into an interrogation room is to get more information about the case or try and gain a confession, right? And that is why it's so critically important, if you ever find yourself in an interrogation room, to ask for a lawyer immediately. All questioning legally has to stop as soon as you request an attorney. And so if you find yourself in an interrogation room, it's because the police think you did it, or you at least know who did it. One of the guides it's called the Reid Technique, and a guide in this manual. It's a popular manual that is used quite a bit in law enforcement agencies. Suggests to avoid creating the impression of an investigator seeking a confession or a conviction. It's far better to fulfill the role of one who is merely seeking the truth. So already the Reid Technique is already saying, kind of switch what the goal of this seems. We all know the goal is this, but kind of switch the way that the goal of this interrogation is. Now, the Reid Technique, in March, I believe it was, of this year, at the biggest law enforcement training or law enforcement curriculum company in the world actually just moved away from the Reid Technique and said that the Reid Technique is actually a terrible way to actually get accurate information, and they will no longer be teaching it in their courses. And so it's a super important thing. It's very good that that's happened. But still, a lot of police officers use that technique today. Right? So what is the Reid Technique? The technique begins with an interview during which a behavioral symptoms analysis occurs. Right? This is also known as human lie detection, right? Or potentially profiling. And we'll talk about those a little bit later in the semester. A lot of police officers that you talk to, a lot of detectives will say, I would never interrogate an innocent person, right? And that's actually a quote from a police officer. I would never interrogate an innocent person. They look for some sort of behavioral symptoms like posture or gestures. Grooming behaviors, that's things like pushing your hair out of your face or scratching your nose or playing with your beard, or eye contact. Too much eye contact is bad. Too little eye contact is bad. There should be a quote-unquote appropriate amount of eye contact, whatever that means. After the investigator suspects guilt, the interview shifts to an interrogation in the Reid Technique. And this is where a Miranda warning is given, and according to the Reid Technique, the suspect should sit alone for approximately 5 minutes. 5 minutes, if you're just sitting there by yourself, very nervous, is a long time to really work yourself up, right? Investigators should prepare an evidence folder or a simulation of one. It doesn't matter if there is no actual evidence in the folder. There at least needs to be the appearance that there is evidence. And then the investigator's entrance should be very deliberate and be done with an air of confidence. The investigator needs to come in as if the investigator already knows that this is the person who did it, to get the suspect to say, oh crap, they know it's me. The process that takes place here of interrogating and confessing is super interesting, right? The interrogator seeks to cause the suspect to view his present situation as hopeless, and his future arrest and conviction are already determined, right? The investigator walks in with confidence, slaps a folder down, and goes, this can go one of two ways. You work with me, it won't be as bad. You don't work with me, it's going to be a lot worse, right? And so you confront the suspect with the evidence against them. And some of that evidence is even allowed to be made up. And we'll talk about that a little bit later. But the investigator seeks to persuade the suspect that a confession will, number one, not worsen his future prospects, number two, might actually be in his advantage to do, and at very least will at least improve his reputation in the minds of the interrogator, and perhaps even the judge, jury, media, and public will be nicer to this person because they weren't willing to make it difficult. They were trying to work with them and trying to get to the truth as easy as possible, right? Major themes of the Reid Technique strategies. There's minimization, maximization, and rapport building. Minimization is kind of downplaying what the suspect did, right? You can offer sympathy, face-saving excuses, or some sort of moral justifications, right? So let's say, for sake of argument, I get arrested for beating my wife, right? Minimization might be a cop walks in and says, listen, I understand why you did this, right? Women can be super annoying. They frustrate us. You probably said you wanted steak for dinner and she probably gave you quinoa, right? I get it. It makes sense, right? We've all been there, haven't we? And then suddenly the suspect's like, well, yeah, that does make sense, right? We have all been there. And they're more likely to confess. There's also the opposite. That's maximization. These are scare tactics to frighten the suspect into confessing. right? So these are things like, oh, you are the biggest lowlife there is. How dare you? You think you're a big tough guy because you lay your hand on an innocent woman? I can't wait to see what the guys over in the jail are going to do to you when they find out that you think you're big and tough. And I'm going to make sure I tell all of them how big and tough you are so that they can see how big and tough you are. That is, unless you're willing to work with me and confess. And then maybe I won't tell them. Right? There's also this kind of knowledge bluff trick in maximization. Like, listen, we've got all the evidence we need. All right? We know you're going away for a long time. You're in a world of hurt. You can work with us and maybe we'll make it a little bit better. But if you don't, it doesn't really matter because I know you did it. Right? And that's kind of this knowledge bluff trick. And there's also rapport building. And rapport building should kind of be taking place throughout this whole process where everyone's roles are pretty firmly established in the interrogation room. So, during interrogations. And I said I would get back to this in a couple slides, and here we are. Misrepresentation of the facts of the case, also known as just lying, are very, very legal during interrogations, right? The police are allowed to lie to you because the idea being, the theory behind this is the suspect is definitely going to lie to us. We should be able to lie to them to get them to confess. So you could say you've got 3 guys next door that have already identified you, your girlfriend confessed, to witnessing all of this, and you're going away for a long time, right? You could also lie and say your dad's not actually dead. He's awake and said you did it, right? So there's also use of techniques that take unfair advantage of emotions, beliefs, or medical conditions of the defendant, right? And so you could say stuff like, if you know that there's a touchy subject, you can keep hammering on that touchy subject to weigh them down emotionally, right? If you know someone is a devout Christian, for example, you could use that information to say, what would Jesus want you to do right now? Or medical conditions. Say someone's diabetic and you know that they're going to need a snack soon. Say, as soon as you help us out, we'll give you a snack so you don't go into a diabetic coma, right? There's also failure to inform the suspect of some important fact or circumstance that might make the suspect less likely to confess, right? I might know that there's 2 suspects. I'm not going to tell them we have another suspect because that might embolden the other suspect, or the suspect in the interrogation room, I guess, that you need to think it's the other guy, right? The only thing that's illegal during interrogations are physical and psychological coercion. Now, how they define that is very, very odd, though, right? It's psychological coercion. I can put you under a lot of psychological stress. I just can't put you under psychological coercion. So I can't psychologically torture you. I can't strap you to a chair and put a drill right up to the side of your head, but not actually push it into your skull. But I can't even get close to that because that's coercion. But telling you that your dad, who you think is dead, is actually alive and says you did it is not coercion. That's just interrogating. And so how they define these things is quite odd. 3 types of confessions that we're going to talk about. And also I would highly recommend that you guys watch this YouTube video here. I'm obviously not going to play it now in this lecture because you guys all have computers, but it's a great YouTube video on the false confession capital of the world being Chicago. So the 3 types of confessions that are present are voluntary confessions, coerced internalized confessions, and coerced compliant confessions. And we'll talk about what all those mean, right? A voluntary false confession is I'm just confessing to a crime because I want to. There's no I don't think I did it, even for a second. I just choose to confess, right? And a lot of people think, who though in the world would ever just confess to a crime just for fun? Well, some people do it because they might be trying to protect somebody, right? And now the typical idea that jumps out is like, maybe the mob will confess to a lower guy in the mob will confess to a crime so that one of the mob leaders doesn't get arrested for it, right? But also imagine, like, would your parents ever confess to a crime that you may have done? Sometimes, maybe, right? I know people that have gotten into fender benders with their parents when they were learning how to drive, and their parents said, quick, switch seats in the car with me, so when the police show up, they think I did it. I can get a ticket, even though I have a driver's license. You've only got a learner's permit. You'll lose your permit. We don't want you to do that, so quick, let's switch it. I'll just say I committed the act. There's coerced compliant, which is where you are coerced into confessing, but you don't actually believe you did. You leave the interrogation room saying, I know I didn't do it, but I was told if I confessed, I would be able to go home. And so I confessed because I thought it was a good thing to do so I could go home. Then there's coerced internalized, and this is the most dangerous one. These are people that confess and then leave the interrogation room saying, golly, I guess I must have done it. I don't remember doing it. Maybe I blacked out at the time. I don't know. But I guess I must have done it. And so we'll talk about those three types moving forward here as well. Quote from a Supreme Court justice here, though, in a case that was overturned, that says that no other class of evidence is so profoundly prejudicial. Triers of fact accord confessions such heavy weight in their determinations that the introduction of a confession makes the other aspects of a trial in court superfluous, and the real trial, for all practical purposes, occurs when the confession is obtained. Essentially, if there's a confession, you don't need any other evidence. There have been people that have been convicted of crimes when the only evidence there even is the person confessed. Because the general belief is, and maybe some of you are having this idea right now, is I would never admit to something I didn't do if it was illegal. Who in the world would do that, right? And so because of that, we don't need any other evidence because he said he did it, right? So 85% of false confession cases that went to trial resulted in a conviction, right? Confessions were a contributing factor in approximately 25% of DNA exonerations. So in a quarter of the DNA exonerations, DNA has proven that the person who confessed could not have been the person who did it. Obviously, a confession has greater impact on verdicts than eyewitnesses or character statements, as we saw from that Supreme Court quote. And jurors do not discount confessions, even when induced by high-pressure tactics. So if we were to go to a jury and say, look, this guy was physically beaten or psychologically coerced into confessing, jurors will still say it doesn't matter. He shouldn't have confessed if he didn't do it. He must have done it. And that's harmful. Right? These are all, confessions are very, very powerful against the defendant, right? Innocent people actually confess to crimes? Well, there's three main reasons. The first is some sort of dispositional personal factor, right? And we'll talk about what those means. But there are certain at-risk populations. There's also police interrogation tactics that might lead people to confess more. And there's also the ideology of innocence, which is probably the most damning thing. And if you learn nothing else about this lecture for your own personal life, this ideology of innocence is hugely important. There are some certain susceptible populations, right? Which we talked about. Innocence puts innocence at risk. And that kind of feeds into that last point also about innocence. If you are too compliant, if you are innocent, you might say, I need to do everything I can to help the police so they don't think I'm guilty. So if they say they want me downtown in an interrogation room, I need to do it. If they say, you don't have to talk, but it would be helpful if you talked, you know you're innocent, so your innocence will protect you. And you want to help. Of course, the problem is you might not actually be able to help, right? Juveniles also are much more susceptible because we always teach juveniles to just believe adults and authorities, right? And so common practices may not also be successful or ethical with juveniles, right? If you tell a juvenile, you can go home to your mommy if you just sign this confession, most juveniles will just say, oh, thank God, let me just get home. Also, mental retardation. Are they actually even competent to waive their Miranda rights? Maybe not, but we see a lot of people that are borderline mentally fit that confess quite a bit. In Convicting the Innocent Confessor, there are three real serious breakdowns in the system. Number one, innocent people are targeted for interrogation for some reason or another. Number two, in the interrogation room, innocent people confess to crimes they didn't commit. Which is a second issue that might happen. Or the third issue is that false confessions fool investigators and triers of fact, because the truth of the matter is, once someone confesses, the police don't keep investigating. Why would they, right? They have a confession. And so there's three different ways that that could cause false confessions. So there's three different ways or areas that should probably be fixed, right? Reasons why confessions trump innocence is there's some psychological factors here. Number one is the fundamental attribution error. This is also known as correspondence bias, right? And this is this basic idea that we have the idea that the person who's driving like a maniac down the highway is just an asshole driver, right? When we drive down the highway like a crazy person, it's because we're in a hurry, right? And so we need to somehow try and justify every little action that we do and try and explain it away to show why we're innocent, right? We also think that on the flip side, as jurors, we don't think that someone else, we could see why we would confess to something we didn't do. We can't see why someone else would. Having not been in that situation and knowing nothing about the pressure they were under, I still know I would never do that thing. That person clearly must be guilty. It's like, well, that might not actually be true. There's also this idea of a truth bias. We tend to typically just kind of believe people, right? And if people say they did it, we tend to believe them that they did it. Police officers and students, though, interestingly, were unable to distinguish between true and false confessions, right? And so when we present these confessions, say some of these are true, some of these are false, which are which, no one can tell, because false confessions seem a lot like true confessions. And why is that? System factors here that cause that, right? Police are trained to construct narrative confessions, right? And so they're trained to construct a confession as a story. There's this idea of non-public details, right? And so they say stuff like, if you say, let's just say for sake of argument, I was found dead, and they thought my wife did it, and my wife said, I couldn't have shot him, I don't own a gun. The police will jump all over her and say, whoa, 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 we never told you he got shot. How did you know he got shot? The only way you could have known that is if you were the one who did it. The problem is, a lot of times police will introduce stuff into, during the interrogation, 2 or 3 hours before that they forget they said, and that's where this person is getting that guilty knowledge from, right? So here's a quote from Detective James Tranium in Washington, D.C. He said, I took a false confession. Years later, during a review of the videotapes, we discovered our mistake. We had fallen into a classic trap. To demonstrate the strength of our case, we showed the suspect our evidence and unintentionally fed her details that she was able to parrot back to us at a later time. So what could have happened with my wife is 2 or 3 hours before the interrogation, which, by the way, she'd never tried to kill me and was never arrested for this, just as a disclaimer, but 2 or 3 hours before she said, I don't even own a gun, I couldn't have shot him, they could have said something like, there were a lot of bullet holes in him, someone who kills like that is pretty angry. Are you sure you weren't angry at him? Did he not do the dishes again? What was wrong? And then 2 or 3 hours later, it's like, wait, I don't have a gun. I couldn't have done it. Like, just look that up. I don't own a gun. And they're like, aha, you must have done it then. So there are these system factors that are present also. Now, well, DNA fails as a protective safeguard. And we think, well, wait a minute. Why? How could DNA fail? At least 19 false confessors have been convicted at trial despite the presentation of exculpatory DNA evidence. So at the trial they said, look, here's DNA that doesn't match my client, which means my client could not have committed this crime, and the person was still convicted. In over 25% of Innocence Project cases, DNA testing was conducted and excluded the defendant during the investigation, yet the defendant was still convicted. So we have this idea that DNA is a safeguard, but it's not really. DNA actually can even be presented to the jury or can be discovered in the investigation, and the person is still convicted of that crime. Now, a lot of research on false confessions. There's some laboratory experiments as well as content analysis of proven false confessions. And we're going to talk about one laboratory experiment that's super important. You'll definitely need to know this for the exam. You'll also need to know the types of false confessions for the exam, for sure, right? So, false confessions in a laboratory, right? This is an alt key paradigm. This is one of the most common false confession paradigms and one of the most famous, right? They get pairs of students to participate in a reaction time task on a computer. Right? Participants report to a lab and are typing letters on the computer, right? If you see, a mammal, press G. If you see a reptile, press H. And just go back and forth and let's see who reacts quicker. You're competing against the other person. They're warned, whatever you do, don't press the Alt key on the computer. Now, if y'all look down at your monitor or your keyboards right now, you'll see the Alt key is nowhere close to like G and H or F and J, whatever those letters are. Even when you rest your hands like you're properly typing, your thumbs are really still not even that close to the Alt key. So you have to intend to hit the Alt key. They're warned, if you press that Alt key, the entire computer will crash. And in fact, all the data will be erased from the computer and the primary researcher will be livid. The Confederate, during the course of the trial, they start racing each other, GH, 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 and all of a sudden, boom, the computers crash. The confederate either admits or doesn't admit that she saw the participant accidentally hit the Alt key. There's an eyewitness saying, I think they did it, right? The participants were given a chance at that point to sign a confession of wrongdoing prepared by the experimenter or not, right? The experimenter, is a professor and comes in, acts all upset, and says, that there's going to be potential punishments also. There could be minimization or maximization that took place as well. On the way out of the experiment, they're also asked by a participant what happened. Now, here's some very interesting aspects about this. 96% of the people, when the computer crashed, confessed to hitting the Alt key. 96%. So virtually everybody said, okay, fine, I hit the Alt key. Clearly the computer crashed. I guess I must have hit it. Someone else saw me do it. I guess I must have hit it. The startling part is, on the way out, when asked by a waiting participant, hey, what happened in there? We heard screaming, we heard yelling, what went on? About half of the participants said, I hit the Alt key. So not only were these confessions somewhat coerced, but they were internalized confessions, right? They actually thought they must have done something wrong. 50% of them. Granted, the other half said, oh, they accused me of something, I didn't actually do it, I just confessed to get out of there. But still showing that people will admit to doing bad things even when they know they didn't do it. Now, another paradigm that's also a very popular, very famous paradigm, cheating paradigm. The cheating paradigm is basically that innocent and guilty parties are accused of breaking rules. And they're analyzed using either minimization tactics or explicit promises of leniency and asked to sign a confession post-interrogation. When no tactic is used at all, no minimization tactic, promises of leniency, maximization tactics, anything else is used, about 46% of people admit guilt who did do something wrong, and about 6% of the people admitted guilt when they did nothing wrong, right? And there was a false confession. When you throw the deal in, the diagnosticity decreases. When you throw in minimization by itself, it gets even less diagnostic. And if you put in minimization plus a deal, the diagnosticity gets pretty close to zero. It becomes super non-diagnostic, right? One of the big things that law enforcement will do and push back against all this research is say, we're going to lose true confessions as well as false confessions. And if you look on this table here, down under true confessions, minimization plus a deal, that's absolutely right. 87% of true confessors confess, and 87% is a whole lot better than 46%. The problem is you also get it wrong almost half the time with minimization plus a deal, and so therefore the diagnosticity is very, very, very weak, and there's potential to make a type 2 error, a statistical error, right? And that's a really, really bad thing to do, because is the bigger injustice a guilty person going free or a lot of innocent people suffering? Which one is the truly bigger injustice? That's a sociology of law question, though. So, at the content of false confessions, we see a lot of evidence discrepancies in false confessions. About 74% of false confessions contained obvious discrepancies between the suspect's account and the true crime details. I've even seen false confessions where someone said, I stabbed the person over 100 times and the person's throat was slit once. And yet they were still convicted, right? Jurors do not use these inconsistencies, though, as evidence between the confession and evidence as cues to accuracy. They don't say these inconsistencies are an issue. They don't care that there are these inconsistencies. Further, non-public information and content also are present, right? False confessions usually consist of more than a simple I did it. Most contain a full narrative description of what, how, and why. These narratives are usually complete with vivid details. Unfortunately, those vivid details are from the police giving them to them, not from the suspect actually knowing any of them. Also, and arguably most troubling, the content of false confessions have assurances of voluntariness in them, right? So it'll say stuff like, I understand my rights and make the following statements freely and voluntarily. Or, having my rights in mind, I want to tell the detectives what happened to my parents this morning. Pretty convincing stuff, right? Also, we see that 45% of confessors either provided a map or a reenactment of some portion of the crime. 40% of eligible confessions contained an error correction, right? They wrote something down wrong, and the police said, no, that's not what happened, cross that out and write this, and they crossed it out. 80% contained a motive, and 60% contained a minimization theme. Of the interrogation tactics contained a minimization theme, right? And so a lot of this stuff is starting to become very, very convincing to a jury who wasn't there for the actual interrogation and says, wow, there's a lot of detail in this confession. There is far more detail than someone who would have made this up would have included. 85% reflected on their thoughts at the time of the crime. Right? For example, I just became so upset and angry about the condition of our brand new house that I just snapped. There's some 40% expressed remorse, like I never did this before, it will definitely be my last time doing it. And 25% even apologized for their crime. Marshall Nunez wrote a one-page apology to his victim at the time of the confession. Now, suggestions for reform here with false confessions. Number one, videotape the interrogations in full, the entire interrogation. From the time you start talking to the person till the time they confess, videotape it. That gives the defense attorney the opportunity to go back and say, you see how the detectives are getting excited here saying, the only way you could have known that is if you're the guilty person. Well, look, an hour before, the police actually told them. Also, strategic use of evidence is a reform, right? You can do things, you can try and elicit a confession by using the evidence you actually have and not lying. Also, there's a suggestion of advocates and expert psychological testimony, right? Have psychologists come and tell people, here's what happens when someone's under this kind of coercion. Here's what happens when someone's been interrogated for 15 or 18 hours. Here's what happens when you promise them leniency. And here's what the studies show, so you really need to take this confession with a grain of salt. So that's pretty much it for wrongful confessions or false confessions. I hope you guys learned something. As always, if you have any questions, please let me know, and I will talk to you soon.